There's a hearing set for February 2nd for a lawsuit that pits the 800 deputy district attorneys for the County of Los Angeles against the newly elected district attorney, George Gascon, their boss. Michele Hanisee is the president of the Association of Deputy District Attorneys for LA County. So, Ms. Hanisee, what is this lawsuit about, and what are you trying to achieve?
Well, the crux of the litigation is we are asking a court to make a decision about whether the prosecutors in the district attorney's office in Los Angeles have to follow the directives of our new employer, which order us to violate the law, or order the law pursuant to our oath as attorneys and government officials, and our duties as attorneys to follow the Constitution and the law. So we are not able to do both, and we've asked a judge to tell us what should we follow, the law or the directives of Mr. Gascon.
So for clarity, this is about the current three strikes law that allows for additional penalties to a suspect called enhancements, tacked onto a crime using a gun, gang affiliation. Mr. Gascon has said, don't file them anymore, just stick with the base crime and that's it. He says as the DA, he has the authority to do that. You say he can't ignore the three strikes law. Why?
Well, because the law says you can't ignore it, and the courts of appeal have said that you can't ignore it. Granted, an elected district attorney has wide discretion in determining what charges to pursue or not to pursue in an individual case. But that discretion does not authorize him to order violation of the law. And it's not even him who's violating the law. It is attorneys who have to go to court and basically misrepresent the law to the court, do things that clearly violate established law, and the things that he's asking attorneys to do violate their duties of professional responsibility, so they could literally be disbarred for what he's ordering them to do.
But again, though, he got elected. Voters knew he was a criminal justice reformer. He was the guy behind Prop 47, which in practical terms decriminalized drug use in the state. Michael Romano of the Three Strikes Project out of Stanford and UC Berkeley Dean Erwin Chemerinsky, they both argue the DA has complete authority as to whether or not prosecutors can enhance penalties from the three strikes law.
All right, there was three questions in there, and I want to answer all three. First, he never announced at any time during his campaign the massive and drastic changes that he enacted the first day in office. He hinted at a few of them, but certainly made no indication to the voters of what his intent was and what he was going to put in place on day one. Secondly, we've heard that elections have consequences, but the voters can vote someone into office, but by doing so, they do not vest that elected official with additional authority. Every elected official has to operate within the bounds of authority of their particular office. And the position of district attorney does not allow him to legislate by fiat or act in the position of the judiciary by unilaterally declaring things unconstitutional because he was elected by the voters. That is not within his authority. As for the study and the press release that came out, I believe that was by Mr. Chemerinsky and Romano, both of those gentlemen are members of Mr. Gascon's Public Policy Committee and his transition team, and they very likely helped write some of the special directives that are now at issue before the court. Strangely, they didn't mention that in their press release, that they had this relationship with Mr. Gascon and were part of enacting these policies.
Not to get too technical here, but the DA says if a prosecutor tells the judge, we're dropping some of the charges against a defendant in the pursuit of justice, that's all you need.
In the interest of justice, yeah, that's Penal Code Section 1385. The law does allow us to request the court to dismiss charges. Now, once charges are filed, the district attorney does not have unilaterally authority to abandon those charges. The district attorney or his representatives can make a motion before the court to do so, but the requirements of such a motion are a showing of insufficiency of the evidence or that the motion is in the interest of justice. There's also another code section, 1386, which says the district attorney cannot simply abandon a prosecution outright. So 1385 makes clear that the interests of justice mean the interests of public safety and the particulars of that individual case, not a blanket policy. And I think it's very indicative of the merits of this lawsuit that the trial court judges have been denying these motions, taking district attorneys, taking them, to task for making such a motion without being able to make a record that there's a legal basis for such a motion. And it's not just about following the strikes law. We have a duty of honesty to the court. We cannot misrepresent the law to the court. It's a really significant ethical violation. And the directives are asking us to do just that, to make these motions when there's no legal basis to do so, and when, in fact, there is conflicting law that says we shouldn't.
The hearing is February 2nd. Michele Hanisee, president of the LA County Deputy District Attorneys Association. Thanks for taking the time.
Thank you.